Welcome, everybody. Thanks again to the invitation by the organizers. Thank you, Mario. Thank you, all the other, for your hospitality at this faculty and for the opportunity to talk to you today. And thank you for the kind introduction. I've been talking to a much more learned colleague yesterday, and he said, you had to start with a story. You cannot just start with something. And he said, oh, I once played guitar. I'm not able to play guitar. I present you a picture. And what's the purpose of the picture? Well, sometimes when academics play party games, they play, what's your famous fictional character? Okay, I would like to play with you, what's your famous legal fiction? Because my talk will be about legal fiction, or something which people tend to refer to as the fiction of non-entry. And that's my famous legal fiction. Okay, that's what you see here is above the 62nd parallel, so in northern Scandinavia. It's a random picture taken from the internet to make my point, because, well, what you see, well, my point is, essentially it's flat, isn't it? Yeah. Legally speaking, these are mountains. This is a mountain area. And that goes back to the first accession of the European Union, at the time European Economic Community in 1972, the northern expansion, where also Norway was negotiated in Sweden and the UK and Denmark came with. And at the time, the European Union was a completely different animal. It was not dealing with so important issues such as migration, but rather with agriculture. And there was a very developed, elaborated scheme of redistributing money, among other things, to mountain farming. Because it's quite difficult to do farming once the slope had a certain degree, and it's difficult to raise crops there, and maybe you can only have sheep and things like that, and therefore mountaineering farmers received additional funding, for example, in the Rhône in Germany or in the Central Massif in France. But when the northern countries entered, they had the difficulty that France insisted that there should be no renegotiation of policies that had been and simply applying the scheme of mountain farming wouldn't give them anything, because of the ice age, it's essentially flat in the northern Europe. And therefore, in the Act of Accession of 1972, there was the introduction of a legal fiction, which is still in place until today. When the European Union speaks of mountain areas, this includes areas north of the 67th parallel. That's my famous legal fiction. To draw just your attention to this talk that has no particular purpose other than you remember me and have particular interest in what we are going to do. So what is my actual topic? It's the asylum border procedures, to which many refer to as a fiction of non-entry. I will get back to as to my personal opinion as to whether this is an actual correct definition or understanding at the end of this. My main argument is that this policy, this asylum border procedure that has recently been introduced and will take effect roughly 1 year from now, as a mandatory policy for the member states, actually interferes with the human rights, namely with the right to liberty of movement laid down in a protocol to the European Convention of human rights. I will develop, let's say, a doctrinal argument. I would say that interferes with this particular right. What is just to briefly mention the context of my talk here that emerges from a more broader research projects, actually a research group of 10 PIs and several postdocs and PhD students. That's the MeDiMi project, Human Rights Discourse in Migration Society, and our core interest is to understand the process that we call human rightization, a process that is driven by the fact that actors in migration society, be it in a legal context, be it in political context, be it in situations of the everyday, refer to human rights to make their claims in migration-related conflicts. That's something which we would like to understand in this project, and in particular, what I'm presenting here has emerged from one of the legal sub-projects of which consists of 3 researchers. One of them is me, and 2 PhD students. Why do I mention that so specifically? First, I would like to draw your attention to this project at all, so you can follow us on social media and come to the conference from 1 year from now. But, well, honestly, I would like to recognize that some of the thoughts I'm presenting here actually emerged from the work from these PhD students, so that it's accredited also to them. Okay, what is the structure of my talk? I will very briefly, because you did a wonderful job in already introducing that, explain you what the essence of these asylum border procedures are, which the European Union is going to introduce. And then I will look into, first, what the Refugee Convention, the Geneva Refugee Convention of 1951 has to say about freedom of movement of asylum seekers. And then secondly, I will look into the protocol number 4, and then to the extent that it does exist, into the case law of the European Court of Human Rights on the particular provision on free movement within the territory of a state. And, well, I will conclude with some conclusions, including my personal opinion on the fiction of non-entry. Let's get started, and I will expect you to, at some point, also read with me, that's a warning, read with me highly complicated provisions and try to make sense out of them, starting here. So I'm quoting actually from the Asylum Procedures Regulation. So what's the overall approach of the European Union in the Asylum Procedures Regulation? There's one core element of continuity, and we should acknowledge that. In particular, in light of other regions and states where this is different. There still is the right to claim asylum at European borders. And that gives you access to the territory of the European Union. You have a right to remain on the territory of the European Union while your asylum claim is being processed. Look at the US-Mexican border, it's different. So we should value that. So there's an element of continuity, but there's also something new that is the subject of my talk, namely following a screening, persons are being identified, asylum applicants are being identified, whose application is being processed in this asylum border procedure. There are different categories, I will not mention them now. Just to keep one point in mind, falling into one of these categories sometimes is the result of your own behavior, of your own actions, so you can control it as an asylum seeker. But at one crucial point, this is not the case. There's a category of asylum seekers, a certain class of asylum seekers, where you cannot avoid falling into this border procedure. And this is actually one of those asylum border procedures where the member states have no option as to whether to apply this procedure or not, where it is mandatory. That is, where the statistical chances of success of your co-nationals from where you are, the success of previous asylum applications being accepted determines as to whether you fall into the asylum procedure or not. And the union-wide level is 20%. So you have no chance of circumventing that, whatever your behavior is. So that's maybe also legally important. Okay, are these border procedures described? I highlighted some terms in red, first to help you get the core statement of the sentence, but also to identify that there might be a tension between these various statements. So, getting back to the first bullet point for a second, I repeat, literally, that's a term taken from the Asylum Procedures Directive, all asylum seekers, including those who are subject to a border procedure, have a right to remain, They are not illegal immigrants. They have a right to remain on the territory pending the decision on their application. Therefore, it comes as kind of a surprise, maybe, that the Article 43, Paragraph 2 of the Asylum Procedures Regulation seems to state something different. It says, applicants subject to the border procedure shall not be authorized to enter the territory of the member states. That comes as a surprise since they has entered. They are on the territory. By very definition, these procedures take place on the territory, and you cannot avoid having entered when you are on the territory, at least if entering means having crossed an international border. This sentence only makes sense if enter seems to mean something different, or the emphasis may be of authorize. Maybe you are still not, you're entered, but you're not authorized. Difficult to say. But so you're on the territory, but you're not authorized to enter. And then it continues, Article 54, Paragraph 1, it says, well, there's a duty imposed on the member states to do something, namely to require the applicant to reside. There's a residency requirement which the member states must impose on the applicant. So it's a state. The provision itself is directed to the member states, so it's not self-enforcing, but the member states must impose an obligation on those who are assigned or who are subjected to the asylum border procedure, namely to reside. And then there are several alternatives, difficult to figure out. But they have something in common, namely they are locations within the member state's territory. Once again, the emphasis is it's on the territory of the member states, and on that territory there are several locations in which the applicant has to reside. These are either at the border, locations at the border, or in proximity to the external border, or by way of exception to a general rule also at other geographical places which are not at or in proximity to the external border. But the general rule is to simplify the statement, you have to stay put at the border, at some location which you must not leave. So that's the general idea. And well, that raises, human rights question. And the entire discourse, as we have observed in MeDiMi, obviously, several times, as usual, so to say, human rights are the main normative resource on which critics of this migration policy refer. But here's an interesting observation, or one that I find interesting. Almost exclusively, almost always, is reference being made, those actors who argue with human rights refer to detention, the prohibition against arbitrary detention. And they are right. So the entire thing cannot function without detaining person. The entire idea that you must not leave, so there must be some force behind it. Okay, and the argument is right. Either member states must use detention in the legal sense in order to ensure that people respect these residency requirements, or they impose something which is not technically not called detention, they call it differently, they use other means, but legally speaking, it quite often will amount to detention in the legal sense. And then it's de facto detention, and usually then it's pretty easy because detention comes with procedural requirement, and de facto detention actually has never observed this procedural requirement, then it's illegal in the first place. Those people who refer to detention are right. That's one of the core human rights issues which this thing raises. But then there's the surprising thing, and that triggers my talk today. I will stop at this point here to talking about detention, although I recognize it's important. It's maybe even more important than what I'm talking about. But I would like to talk about something else. Namely, what is the legal situation in terms of human rights in a situation where a restrictive measure, an area-based restriction, does legally speaking not amount to detention? And they do exist. Being confined to a small Greek island of a particular size is not necessarily detention. But you cannot leave. There's not even a ship. So that's physically impossible. Also, it's legally forbidden. So people are imposed, restricted on a particular area, a small Greek island, but it's not detention. And exclusively focusing on detention as a normative claim why this raises an issue of human rights has the downside, the discursive downside, of somehow giving the impression, if it turns out that it's not detention, it's just fine. There are no limits. If you exclusively talk about detention, you give the impression that area-based restrictions that do not amount to detention are beyond human rights limits. And the remainder of my talk today will argue against that point. So I'm talking about area-based restrictions which are legally speaking not detention. So, okay. One of the resources where this human right to freedom of movement, to liberty of movement may be derived from is the Refugee Convention. Well, what is the legal status of the Refugee Convention in the Union legal order? As you might all know, this, according to Article 71, paragraph 2, it has a constitutional status. The European Union, although is not a state party to, or not a party to the convention, but it had bound itself on the highest level of its law to observe the Geneva Convention, and therefore it's incorporated on the constitutional level. So when we find out that these measures would violate the Geneva Convention, we automatically say it's unlawful under EU law. So it makes sense to look into the Geneva Convention. Well, there are two provisions. I gave you the almost entire wording here. There are two provisions that deal with freedom of movement that may apply to asylum seekers, and it's incredibly complicated to make sense of them. And if you look into the literature, there are so many different opinions about how they should be construed and what their relationship is. It's actually clear that 31 paragraph 2 applies to the situation of first arrival. So that's the first phase. Most people say it's not, when you illegally cross the border, you're not under the coverage of 31 paragraph 2, but at the very moment you are registered. So everybody is in agreement then. And it must be necessary. There's a necessity requirement imposed on the convention states when they restrict access to the entire territory. So that may translate probably in EU law into the principle of proportionality. So that has also a backing in the Geneva Convention. But then again, this ends when you are regularized, or by way of reference in the paragraph 1, when you are authorized. What does that mean? In our case, are people who are registered after the screening process and assigned to the asylum border procedure, are they regularized, authorized? Some people argue that gaining the formal status of an asylum seeker and your application is being processed, you are under, so your status of this first arrival ends and you have a higher status of protection. That is Article 26, the second provision. Most people doubt that. Since Article 26 says you have a very strong claim of freedom of movement within the territory, when you are a refugee who is lawfully in the territory. What does lawfully mean? There's a highly complex system of the Geneva Refugee Convention. I will not even try to explain that here. James Hathaway is the champion who first really systematically developed the idea that the Geneva Convention is built on the idea of a graded system of acquiring rights. Some rights even apply before you arrive or at the border, that's non-refoulement, and others require time or legal events. And in the language of the Geneva Convention, being a lawful refugee is quite progressed. That usually seem to refer to people whose status determination procedure is being concluded already. And that means the strong protection of 26 probably will not apply to asylum seekers, and at least probably not, even more probably not, to people who are asylum seekers and assigned to the asylum border procedures. But it's subject to debate. There is no centralized authority interpreting the convention. Other people have different opinion about that. But it seems to me that the stronger legal arguments can derive not from refugee law, but from human rights law in a narrow sense. And here we have Protocol number 4 to the European Convention of Human Rights. What's the legal status of these protocols to the European Convention of Human Rights? Well, they are part of the body of human rights of the European Convention, and therefore they are regarded as the main source of inspiration for interpreting the Charter of Fundamental Rights. But here we have a problem. Actually, the provision of Article 2, paragraph 1, which is reproduced here, has no mirror provision in the Charter. Almost all provisions of the Convention have their corresponding provisions in the Charter of Fundamental Rights of the EU, but that one has not. Difficult to explain why. Maybe the reason is that Greece has not signed and ratified this protocol. So they were maybe uncertain as to whether this is actually should be part of EU law. But then again, we have settled jurisprudence of the European Court of Justice that in order to rely on a second source for fundamental rights in the EU, namely the so-called general principles of EU law, it's not necessary that every single member state has recognized that. He has, in Mangold, he has said there's a prohibition on the discrimination on age, although only 2 member states had that in their constitution. So I do not doubt that Article 2, paragraph 1 of Protocol number 4 has the status of a fundamental right in EU law. When I'm able to demonstrate, if you believe me, that asylum seekers are covered by the protocol, you will believe me that it's part of EU law, I'm sure. Okay. But then the problem is, do asylum seekers actually fall under Article 2, paragraph 1, which says that everyone, okay, asylum seekers are everyone, lawfully within the territory of the state shall have the right to freely move within the territory. That almost literally repeats a provision of the Universal Declaration of Human Rights and of the International Covenant on Civil and Political Rights, which was actually drafted later than the protocol itself. So we have that in universal human rights law, and we have that in European human laws. But the very idea that's a fundamental right to freely move within the territory in which you lawfully reside. Are asylum seekers lawfully residing? That's up for discussion. I will come up with the main legal argument in a minute. What will be the consequences once you say yes, asylum seekers are lawfully within the territory of the European Union, and including those who are subject to a border procedure? The main consequence is, well, that any restriction on freedom of movement within the territory must be in accordance with law. There's a legal basis requirement, and you violate, if it not even complies with domestic law, then it violates the convention, okay? That's not so strong the point, but there is a proportionality requirement, and here it's a stronger one. It's the one you know from Article 8. Is this necessary in a democratic society in view of a certain limited number of public interests, of legitimate grounds? The core provision of which is ordre public, public order. But it's notably not any public interest which is sufficient to restrict the freedom of movement. So mere administrative convenience would not suffice. We have jurisprudence on that from committees and also from the Court of Human Rights. Public interest is the broader concept. That the European Union finds it nice to keep these people put because it's easier to deport them afterwards. That does not suffice. And having filed an application, the chances of success of which are minus 20%, I don't buy that this is a requirement of ordre public. Yeah, that's nice for the European Union, and it has certain policy goals. You explained that to us, what the governance idea is. But falling into a particular class of asylum seekers does not subject you to human rights limitations. That's my core argument. So it will be difficult, at least at the level of legislative balancing. Obviously, in an individual situation, imposing that restriction may be legitimate. But this is the Article 8 requirement of finding a fair balance, and arguably that needs to be looked into on a case-by-case basis. And this is actually different from what the European Union says. The European Union defines, the European legislature has defined certain classes of migrants which fall under these restrictions without any discretionary decision making. And therefore, although the outcome is not determined, an entire new field of making claims and arguing cases is opened up when this provision is applicable, provided that this provision is applicable. I did my proper research. There's one case. And of course, in the European Convention, one case doesn't make a summer. But in particular, when it's from 2007, and the facts of the case even predate the Europeanization. But look into the language, what the European Court of Human Rights said. Let me first explain the facts of the case in order to make you understand how closely it resembles what we today call European asylum border procedures. It was a person with an Aufenthaltsgestattung, one of the different names which the Germans give to a residence permit. So, the Aufenthaltsgestattung is the legal status of an asylum seeker once the person is registered. It's exactly what we're talking about, registered asylum seekers. And even today, it's still called Aufenthaltsgestattung. That was the effect of the case predated the Asylum Procedures Directive, but the Germans didn't change anything. They hand down to an asylum seeker the Aufenthaltsgestattung, which is actually, in this case, the directive is actually modeled after the German concept. Okay, so it's directly applicable to asylum seekers. And German policymakers had at the time, and actually still have in many instances, the policy of restricting the movement of asylum seekers. In this case, not at the external border, because Germany, apart from the international airports and some tiny fractions of the Baltic Sea, does not have external borders. Okay, fine. But at the county where the people are living, in the city or in the region. They must not leave that without permission from the alien's authority, otherwise they get fined. Yeah. So there is a residency requirement which, according to German courts, does not amount to detention. That's plausible. Exactly the situation we're talking about. Residency requirement of asylum seekers. What did the court say? It did come up with a strange solution. Have you read it? It's crazy. Okay, first of all, it says that's a settled jurisprudence. This lawfully within the territory must be read as a reference to domestic law. So domestic law, not the convention, defines who is lawfully resident, lawfully within the territory. That makes sense. In this case, it was the German legislator. In our case now, it's the European legislator. It defines the legal status. So we must look into the Asylum Procedure Directive. What does it say? Are these persons lawfully within the territory? Well, do you remember the red words which I gave you? Right to remain? Doesn't sound unlawful to me, actually. Yes. They are not authorized to enter. Okay. When asylum seekers leave the location to which they are assigned, to which this residency requirement applies, then, so the court says, then they move beyond what the national legislator or the domestic legislator, in this case the EU legislator, has granted you. So as long as this person at the time remained in the particular city, he was lawful within the territory. At the very moment where, actually it was an activist and wanted to organize a conference in another part of Germany, and the authorities didn't give him a permission for that. At the very moment where he did so anyway, he was not lawfully within the territory anymore. And therefore, this strange, so long as they comply, they are lawful within. Strange outcome. That means that in asylum, if we apply that to the European asylum procedures situation, so as long as persons remain within the location at the border, at the proximity at the border, or exceptionally at the other geographical location assigned by the member states and notified to the Commission, they are lawfully within territory. And then they can legally claim a right based on Article 2, Paragraph 1. So, difficult to make sense of that, but I understand it to mean the convention does not have direct effect. You have to comply first, but you can raise a claim. And as long as you remain within the location, you have a human right, which triggers a requirement of justification. The member states, or maybe the European Union, public authorities have to come up with a justification of keeping these restrictions in place, based on the grounds in Article 2, paragraph 3 of the 4th protocol. And then a fair balance has to be struck. So, not in every case will this be unlawful as a result, but as long as asylum seekers comply with the residency requirement, they can make a human rights-based claim, and member states and or the European Union has to justify keeping the restrictions in place. I think if that is the law as it stands, it makes quite a difference as to whether there is a human rights limit to area-based restrictions that do not amount to detention. This is my conclusions. My conclusions say asylum seekers in the European Union do enjoy a right to freely move within the territory of the member state in which they have the right to remain pending a decision of their applications. There is a human right. And the personal scope of these human rights, and by implication for EU fundamental rights, includes those applicants who are subject to the asylum border procedures, as long as they comply with the requirement to reside in the designated location that is drawn from the case law. And accordingly, as a consequence of that, any interference with these rights must be justified on one of the grounds listed in Article 2, Paragraph 3 of the 4th Protocol to the European Convention of Human Rights, and must comply with the principle of proportionality. And it's up for another talk to argue as to whether legislative balancing is possible in this respect, or whether this implies, as it does under Article 8 in expulsion situations, a requirement of an individual decision-making in a case-by-case assessment, in which case, at minimum, the statistical chance of success clause would violate EU fundamental rights. So as a result, coming back to Northern Scandinavia and my famous legal fiction, well, I would argue that describing the asylum border procedure as a fiction of non-entry tends to obscure the legal situation. Namely, that the applicants are lawfully within the territory of the European Union, in this case of the border state, and can therefore make a claim they can claim a conditional right to move to other parts of the territory. Conditional means restrictions can be justified, but need to be justified. And my formulation here, they are prevented from moving to other parts of the territory. That is actually my rephrasing of the actual meaning of what the asylum procedures regulation in legal substance says when it reads, they are not authorized to enter the territory. That means enter other parts of the territory without authorization, and therefore it doesn't make sense to call it a fiction of non-entry. These people have already entered, and it's about restricting or not their freedom of movement within the territory, and therefore, if we want to be legally precise, we should not call it a fiction of non-entry.